Good evening, everyone, and welcome to the Trustee Handbook Book Club. I'm Ron Kursop from the OWL Library System, and joining me as co-moderator today is Erica Jens from the Southern Tier Library System. We're glad to have you here for what I expect will be a very practical session on one of the more consequential and interesting areas of trustee responsibility, understanding the laws and regulations that shape how your library operates. You don't need to be a lawyer to serve effectively on a library board, but you do need to know enough to ask the right questions and recognize when to get help. Tonight's session is designed to give you exactly that grounding. We'll start with an overview of our topic, and then we'll hear from our audience on questions you've already submitted, and then we'll get into our Q&A. Before we get started, let's take a quick look at who's in the room. Please drop a short introduction in the chat if you don't mind, your name, your library, and how long you've been serving as a trustee. It's always great to see everybody who's joining us from across the state. This program is supported through our promotional partners, the New York State Library, the Public Library System Directors Organization, PLSDO, and the Library Trustee Association, and the Public Library section of NYLA. Thank you so much. We appreciate your support in making programs like this possible for boards across New York State. So what's going to happen today? So here's what we have planned. First, we'll cover the core elements of laws and regulations as they apply to library trustees, drawing from the trustee handbook. Then we'll address some pre-submitted questions that were sent by all of you, our audience, in advance. And after that, we're going to open things up for the live Q&A. Your real-world questions always make these conversations stronger, so we appreciate any questions that you put in there. For a quick tech note, any of the live questions you like answered, please use that Q&A button that you'll see at the bottom of the screen. Those get added to a queue, and Erica and I will go through those as best we can. For comments or general thoughts, you can go ahead and put those in chat, but for those questions, please put them in the Q&A section. Helping Erica and I behind the scenes tonight is Kirsten Kruger from the Mid-Hudson Library System, managing the technical side of things and keeping us on track. We're very glad to also have Rebecca Smith-Aldrich as our presenter. Many of you probably already know Rebecca Smith-Aldrich, the Executive Director of the Mid-Hudson Library System, a co-author of the the Handbook for Library Trustees of New York State, and the co-founder of the Sustainable Libraries Initiative. She has spent more than 25 years working with libraries across the Hudson Valley, and her depth of knowledge and trustee governance is the reason this series exists. Rebecca, we're really happy to have you here again tonight. It's great to be here with you, and I'll turn it over to you to get us started.
Thanks so much, Ron. You always did such a great job on those introductions. And thanks to everyone who's here tonight. I wanted to give a shout out to that new face you saw at the top of the hour. You saw Kirsten Kruger, who works here with me at the Mid-Hudson Library System, but she is also the incoming president of the New York Library Association. So go, Kirsten. She'll be taking office later this year, but meanwhile is getting to know folks and hear what the concerns are from people around the state. So you may get to see her as she makes her way around the state to learn about your issues and different systems across this great state of New York. So thank you, Kirsten, for jumping in to help us tonight, and thank you for your service to the New York Library Association. So tonight we are tackling laws and regulations. Super broad topic, as you all know from coming to this event in the past and hopefully reading the handbook for library trustees of New York State. And so, of course, we have a big old disclaimer for you before we start the content tonight, which is that we are not lawyers. We went to library school. But all along the way, we figured out how laws and regulations intersect with operating, managing, governing a library. So what we're going to do here today is help you get the lay of the land so that at least you know what to ask. You know when to kind of your radar should be going up, like, ooh, I think that intersects with this. Are we sure we're on the right side of that? Because you really, I feel you have no chance of knowing everything on this topic. Ron and I don't know everything on this topic. So when you think about all the different laws and regulations that are out there, there's no such thing as library law. In New York State alone, there's over 30 sections of law that intersect with library stuff. And there's no way we're going to cover them all here tonight. And like we always say, you don't have to know it all, but you do need to know enough to, again, ask good questions, make sure due diligence is happening, and have a really good sense of when something has crossed the line from, oh, that's an interesting thing to debate at the board, to like, oh, we need some help with this one. And call in your library system and helping your library system understand what's going on, and they're going to help you know when you're going to need a lawyer. So that's our hope here tonight. We're going to give you some of the very basic building blocks of the library's legal existence. We're going to talk about the top 10 areas of law to be semi-aware of, if not pretty up on. And then, of course, we're going to give you some hints of when you should be calling that lawyer. But we'll do all that pretty quickly so we can get to your questions, which, as we all know, is probably the most interesting part of these Trustee Handbook book clubs. So here we go. We're going to start at the beginning of where does your library get its legal or what can be called corporate existence? All libraries in New York State are considered education corporations, right? You don't fall under, you're not classified as a nonprofit. You're a not-for-profit education corporation, which again doesn't mean you fall under all of nonprofit law. It also puts you in squarely into education law, but there's some exceptions. So we're going to talk about those today. But at the very beginning, at the dawn of time for your library, you were made a legal entity in the eyes of New York State. If you're a special district public library, that was done through legislation that was passed up in Albany that allowed for a vote that elected trustees gave you a budget and brought this library into existence. The association libraries, municipal libraries, school district public libraries, they started with a charter document. Special districts also ended up with a charter document, but not until after they got through that origin vote that they had to have. So your legislation for a special legislative district library is a very key legal document you should be familiar with. And then all types of libraries have a charter from most likely the New York State Education Department. Some of you have a very old charter. It might be from the 1800s. It might even just be one big document that's framed in your library and legit, that's your charter. Other libraries that formed later in history, they might have a package of documents that came from the state education department that outlined, and these are the kinds of things you're going to see in your charter, your legal service area, how many trustees you're supposed to have. So believe it or not, that answer of how many trustees are you supposed to have, you might think it's in your bylaws. The answer is actually in your charter, and your bylaw has to answer to your charter. So make sure those numbers match. If you have a range of library trustees in your charter, you have to have a specific number in your bylaws. The other document that you all have is kind of like less of a document that you can frame and put on the wall, but a process that you go through is called registration. You or your libraries hopefully all got registered right after getting chartered. And being registered means you comply with all the minimum standards, which we're going to take a look at together tonight. And then each year you file an annual report to the state that make sure you are still certifying that you meet all of those minimum standards. And that's an action the board takes to certify that. So keeping in good standing in the eyes of New York State requires those actions, that annual action to stay in good standing by maintaining your registration. And your registration is really important. It's not just complying with a checklist of things. It is what allows you to legally receive tax dollars at the local, county, and state level, which my guess is make up a very large portion of your revenue. So you want to be in good standing. So we're going to look at those minimum standards together tonight. Super important also is to really be clear on what type of library you are. You've heard us talk about this in other sessions, and you see it pulled out in the trustee handbook in a couple of different chapters, how important it is to know, are you an association library versus a municipal versus one of the two types of district libraries? Because a lot of the answers to your legal questions depend on knowing that answer. I guarantee your director knows the answer. So if you're not so sure, just ask your director and they'll get you square with that information. But as I said, the minimum standards are something trustees have to be aware of. So this is the deepest part of law I'm going to take you into today, which there is authorization for this list in education law, and it directed the education commissioner, so the head of the state education department, to develop regulations that define minimum standards for every public and association library in this state. And you're looking at the list. So I want to just point out right away, there's this amazing website, and Ron was on the committee that helped make it, so you know it's good. But there's this page on the state library's website called Helpful Information for Meeting Minimum Public Library Standards. It's really well done. It explains the regulation, it gives you examples, it really, I think, points you in the right direction of what you need to know about each of these things. So when you say, oh my goodness, Rebecca went so quickly through these, when you get the slides, just click on that link and it's going to walk you through them at the pace maybe that's more comfortable for you. But what you're looking at here is Education Commissioner Regulations 90.2. There's 14 minimum standards all association and public libraries must be in compliance with to retain your registration. Now, I don't want to be alarmist, but every once in a while you might find you are not in compliance with one of these and you might really kind of flip out about it. But please know and calm down because there is something called a variance process, which you partner with your public library system to come into compliance. So if you discover that you're out of compliance on one of these, you don't automatically lose your registration. There's a process to go through to come into compliance. And particularly for newer trustees or if you have a new director, they may uncover that, oh, I don't know that this was ever really done. You're going to say, okay, let's prioritize getting into compliance with these. But I would say I'm pretty confident all of you have bylaws. So, hey, check one. We've all got number one done. Number two, long range plan of service. It must be based on community input. So when you're looking at your long range plan, maybe it's called a plan of service or a strategic plan. You also want to make sure you're very clear on the methodology that was used to create that plan to demonstrate that the board and staff, you had some kind of methodology that invited community input. And there's lots of different ways to go about that. You see a whole chapter on planning and a nice 1, 2, 3, 4, 5 step process in the appendices of the handbook itself. Number three is something to be up on, making sure you get an annual report to the community out every year. And a newer aspect to the regulation is that must be board approved before it goes out. So you should see it and the board should vote and say, yep, that's our report to the community before that goes out. This should be a really strong PR piece for you with a little bit of something for everyone, right? A report from your director, report from the board president, pie chart of how you spent the money, pictures of folks at your programs, a little list of outcomes that you've achieved over the year. You can take a look at other libraries around the state, how they do that. We have so many really talented people in the state when it comes to graphic design and storytelling, but it's something to make the most of. It's a great opportunity to tell your library's story and as well to people who maybe don't come to use your library ever or on a regular basis. So when you think about all the folks that have the right to vote on your library budget, but maybe that number is quite a bit bigger than the folks that come to use your library, just a reminder that annual report to the community is a great opportunity to tell your story. Now, policies is an area we've talked about several times over the years in this series. And there is a new change to the regulation that is very clearly requiring a certain set of policies that you must have, which goes into effect on January 1st of this year. So when you click on helpful information for meeting minimum public library standards, you're going to see that list. And shout out to the state library right now. They're doing a webinar series focusing on each of those policies that's required. If you're not tuned into those, you can check out recordings. They're going to have those on the state library's website. So hopefully you find those helpful. You must present a board-approved budget. If you have a budget vote with the public voting on that, you've satisfied that one. You should also have your budget on your library's website. Just to note, your plan, your annual report to the community, your policies, your budget, all should be posted on your website. That's now required in the regulation. Number 6 is something that kind of lives in the wheelhouse of your library director, which is evaluating the effectiveness of the collections and programs and services that you offer to the community. Number 7, in the regulation, you're going to find the minimum number of hours you must be opened, which is based on the chartered service population. So for example, if you serve 2,500 people, you have to be open a set number of hours and you cannot go below that number. So that's an important threshold to understand as you do financial planning. Number 8 is one of the tougher ones. It's this general statement of facility that meets community needs. Going back to number 2 of understanding community needs, you need to understand them so you can have a facility that meets them. And then, of course, you must be compliant with the Americans with Disabilities Act. You have technology that meets communities' needs, all that good stuff. So that's a tougher one and a very broad category. It's good to read the language on the state library's website on that one. Number nine, your staff delight in bringing this one to life, making sure you have programming that address community needs. But again, you have to have assessed community needs so you can match up programming that actually responds to them. Number 10, a circulation system, which might sound like part of the human body, but it's actually software, right, that helps to circulate items from your library into the hands of patrons, as well as equipment and connections. So technology, computers, broadband connectivity that meet the needs of your community. Number 11, basic information about your library: address, phone number, website. How do I get a library card? What hours are you open? That should be on a bookmark or a handout that's at the front desk of the library. It should be clearly on your library's website. And it also encompasses all those other things I said have to be on your website: your plan of service, your annual report to the community, your policies, your budget. All of that also has to be on your library's website. Number 12 is also tied to your service population number. So this is a paid director with appropriate education. And how you would know what appropriate education means is found in the regulation. And again, clicking on this link on this slide will bring you to the chart to tell you basically what degree your director must have. Smaller library directors are not required to have a master's in library or information science. Once you hit a certain threshold, the director must have that master's in library or information science and be eligible for what's called the Public Librarian Certification in New York, which basically just says you prove you have your master's degree and you're keeping up with the professional development requirements. So for your director to maintain their certification, they have to get 60 hours of education at least every 5 years, and they have to maintain that with the state library. Number 13 is again in your director's wheelhouse. They're making sure your staff is getting technology training of some kind every year. That's up to the director to set what the topic will be, but it should be relevant to what's going on with the patrons in your community. And then number 4, the regulation is asking you to make sure the library is not working in isolation, that you have partnerships across the community to make sure you're not being redundant, that you're helping fix problems faster by working together and having stronger collective impact. So making sure we're documenting what partnerships we have in the community and why we have those partnerships, how that helps us achieve the goals that are set in that long-range plan of service that, again, ties to those community needs that you assessed. So that was a lot, right? But again, you've got a great reference tool there from the state library, a great webinar series that's going to help you with those new policies. They may not be new to you. You might already have them. But if you don't have them, it'd be good to find out like now in June, since you need to have them by January of next year. The way I decided to do kind of like the rest of this, because as I said, this is where I'm pulling you the deepest into the law or regulation. But what I did here is I was feeling very David Letterman, and I created a top 10 list of laws and intersections with law that I think trustees should have on their radar, right? We're not, again, don't need to be an expert, but you need to know they exist and that sometimes your policies and decisions you're making or how you run your library or your board rub up against these laws. And we need to be compliant with them to make sure we're fulfilling our duties as library trustees and library leaders. So number 1 should come as no surprise, right? Because we said the library community in New York is most closely aligned with education law here in New York State. And probably the 2 areas of law you're going to come most into contact with is Ed Law 226, which imbues library trustees with the power that you have to govern the library. That's a pretty important origin story, right, for library trustees. And 259 is incredibly important because that's where you find the statutory right to have voter directed funding. So that's where it says right in New York State law, public and association libraries can have the voters vote how much to tax themselves for library services. Incredibly important to the fiscal solvency of your library, right? So that's where you find that origin story for both trustees and most likely your funding source. And just, I can't resist the chance to say, you should be having a public vote on your budget to make sure you've got sustainable, stable funding. Number 2 should be not a surprise to you. Anyone who's come to these workshops in the past knows about the library patron record confidentiality law. This is not in education law, which is kind of puzzling, but it exists, and that's really great. So in New York State, we've got a law that says patron usage of your library, what books they're taking out, what they're researching, what program they came to, all has a protection in terms of confidentiality. And so that's not an option. Your board and your staff must follow that law. So you probably have a policy related to this topic, but what it should say is, we follow this law. Public officers law I've got here is number three, and we've talked extensively throughout this series about open meetings law. We've had standalone sessions on open meetings law. We've brought in Kristen O'Neill to talk to you about open meetings law, so I'm not going to spend a lot of time on it today. But just so you know, that falls under an area of law called public officers law, which is also where you find indemnification as a library trustee, as well as the freedom of information law. That's where that lives in New York State law. And again, freedom of information law in New York, a lot of us call it FOIL, F-O-I-L. That applies to all public libraries in New York State. And association libraries are encouraged to adopt policies that have you very closely aligned with that law. As an association library, you have an escape hatch, but you want to show good faith in the intent of that law, which is being transparent and getting people information they need to understand what's going on at their library. So association libraries, just put a little asterisk next to that. Make sure when you're looking at sample policies related to FOIL, you get the association library flavor of that one. Number four is where we actually do fall under nonprofit law in New York State. And those of you who might be familiar with the nonprofit world might remember the Not-for-Profit Revitalization Act. It actually was passed over a decade ago now, which is like making me feel old thinking about that. But the State Education Department's Office of Counsel issued a ruling that libraries have to follow two aspects of that law. So you have a very clear answer about this. You must follow the conflict of interest aspect of this law. So your library has to have a conflict of interest policy, as well as a disclosure form that you as trustees, as well as staff in charge of fiscal decisions, fill out every year, where you disclose whether or not you have some kind of intersection with someone you do business with, or where there might be the opportunity for you to make money. You have to be very, very clear if decisions are being made where you or a family member might benefit, or you have an interest in a business that might be doing business with libraries, that has to be revealed so that the whole board is aware of that and can make sure you've recused yourself at the appropriate time when decisions are being made about awarding a contract or looking through requests for proposal responses. Now, on whistleblower, this is where I know you all love me when I say this, but the law technically says you have to have 50 or more employees in order to have a whistleblower policy. But I'm going to say to you, I think all libraries should have a whistleblower policy. It's just good governance to be very clear and on the record that, of course, we encourage someone stepping forward and letting us know if something is going wrong to illegal, right? That's something that you need to know. So if you've got a situation in which the bookkeeper is acting kind of squirrely, you want someone to speak up about that. If you've got a staff person noticing that the director is walking out the door after sticking their hand in the donation jar to go grab a cup of coffee, you want someone to bring that up. And you want that person to have job protections for doing so. So I do encourage all libraries to have that whistleblower policy. On the second-hand side here of 5 through 10, reserve funds and investments, how we're handling the public's money or really any money that you've been entrusted with. We should be following the Office of the State Comptroller best practices. And for investments, public libraries, you have a very limited list of options for investments. Those options are listed in General Municipal Law, Section 10. Association libraries, you have more latitude with investments, but should be very conservative whenever investing public dollars. And you'll probably want to follow more closely what General Municipal Law is doing for your public revenue for association libraries. Number 6, tax exempt status. I know we've talked about this before, but I couldn't resist putting it here. Not every public library has federal tax exempt status. You have it inherently as a government entity, but some of you have dual tax exempt status in the eyes of the IRS. So for public libraries, you need to be aware, do you have that dual status? And if not, if you do, there's certain benchmarks you have to hit for reporting on that designation that you have. If you're on the library board and you have a separately incorporated friends group, you also need to be on top of whether or not the friends are in compliance with maintaining their tax exempt status with the IRS. Now, number seven is an enormous area of law, and it is one that you 100% need a professional to help you with. Even your system staff are going to tell you you have to call a lawyer on a lot of these topics because employment law is very complicated. There's employment law at both the state and the federal level. It impacts hiring practices, it impacts pay, it impacts overtime, it impacts working conditions, leaves, all different types of leaves your staff have rights to. This is a very complex area of law, and I'll say it again, you definitely need professional advice, lawyer or HR professional that you consult with to help you with personnel policies, questions that come up, all that good stuff. This is where you find civil service law, Fair Labor Standards Act, all those important things that people have worked for many, many years to put in place to protect workers, keep people safe, and make sure we're protecting employers while we're at it. So, big, big area of law. Number eight, Americans with Disabilities Act. This comes up frequently with your library buildings when they're not fully compliant with the Americans with Disabilities Act. You're also going to be hearing a lot about this as the rules surrounding accessibility of your library's web presence is changing. Now, they did just extend the compliance date for this, so you have a little more time if you were unaware of this. But unfortunately, we all need to figure out a plan to come into compliance with this on the web as well. And I will say something I have said several times in this workshop series. There's no such thing as being retroactively compliant with ADA, meaning you can't be grandfathered in. That's not a thing. All libraries, even historic buildings or really buildings on the historic register, you all still have to be compliant with the Americans with Disabilities Act. The Children's Internet Protection Act, you may or may not be aware of this. If you were a library trustee back in the 1990s, you would be very aware of this one, but I bet we don't have a lot of folks online that were trustees back in the 1990s at this point. This is sometimes referred to as CIPA by its acronym, CIPA, and it's tied to a federal rule that requires, if you're going to apply for the E-rate program, which is a federal program that allows your library to be reimbursed for broadband connectivity charges and networking equipment, you also have to have the Children's Internet Protection Act policy in place, which mandates filtering of our public computers to make sure that children are protected from some scary stuff online. Now, back when this was passed, super controversial because there was not software that could filter in a way that didn't deny people their First Amendment rights to seek information at public libraries. Today, it's a very different story. You probably already have some type of filtering on your computers already to minimize a lot of the very dangerous stuff that's online, from malware, spyware, as well as some material that would be inappropriate for folks. But you must have a policy that says, maybe you're going for the E-rate, or even if you're not, you want to have an internet policy that protects folks and make it very clear that if is software filtering internet content, your public has the right to ask for that to be turned off for an individual session. So you must comply with that if someone asks for it to be turned off. And number 10, which really should be number one, is the First Amendment of the US Constitution. So defending free speech, promoting intellectual freedom. This is stuff we talk about all the time as library people. You've got great collection management policies that help defend decisions made in your collection. You are helping people be heard in your meeting spaces. Even your bulletin board at the library intersects with First Amendment rights. So that's a law where, again, sometimes you need some guidance on that one. Your system may be very well versed in that because that's something your professional libraries staff in your building, as well as the system, literally were trained on that stuff. So that would be a good source of information if you have trouble on that one. But like I said, tons of resources out there. And again, you'll get all these slides in a follow-up email along with other resources that we mentioned here tonight. But each one of the things you see here after you get to you see your public library system, that's an email or a phone call, right? The rest of these are all links that you can click on and are going to bring you to things that could be helpful to you. You will get quickly overwhelmed. I'm just going to tell you right now as you click on these things. So my advice as a trustee is to start with your library director. Your library director, if they went to library school, they know a lot of this stuff already. If they went to the public library administrators cohort, they know a lot of this stuff already. If they didn't do either of those things, you've got your system, your public library system staff as your teammate. And a lot of these things, they can often be the backstop for a lot of issues. They can help you save a lot of time, energy, and sometimes money answering questions, because these are things that are usually not the first time someone's asked. But every once in a while, there's going to be a time when you need to call a lawyer. Now, some of you may have a lawyer on retainer, but my guess is more of of you than not do not. And you're a little worried. How much is that going to cost? When do I need to pull that trigger and incur that cost to my library? Now, I put together this little list, and my first answer was a little tongue in cheek, but honestly, if you call your public library system and they say, woo, you need a lawyer for that one, please trust them. So, when we're here tonight saying for your employment law issues, particularly your personnel policy, you need a professional. It could be a lawyer, it could be an HR professional, but you need a professional on that one. Trust us when we say that. We've learned those things the hard way. If you are sued, presented with a court order, you need a lawyer on board to help you through those things. If there is a law enforcement inquiry, state trooper, local police, county sheriff walks to the door, says, I want XYZ from you. Maybe they have the appropriate court order. Maybe they don't know they're supposed to have that court order. You're probably going to need a lawyer to help mediate that conversation and help navigate you through that without harming the relationship with the law enforcement officer and making sure the library is following what you are beholden to follow, which is the patron confidentiality law. Severe personnel actions. It's not any personnel action, but when you're taking action against an employee, maybe they have exhausted their progressive discipline path and it's time to separate them from the organization, you're going to want a lawyer involved in that conversation. Lawsuits involving unlawful dismissal are the number one reason nonprofits get sued, and that encompasses libraries as well. So you're probably going to need some legal advice to walk you through that one. And there could also be other situations where perhaps there's a severe harassment complaint, like a staff person is accusing the director of sexual harassment or bullying. You're going to want a lawyer to advise you in that situation. First Amendment issues that crop up, which unfortunately has been a trending issue across libraries over the past 6 years. Some of those your system can help you navigate, but every once in a while they're going to hit a point where your system's going to say you need to get a lawyer involved in that one. So challenge to library materials. Some of them are run of the mill, you can handle it. Others of them are just powder kegs waiting to go off. Increasingly, issues around your meeting space. If you've got a program the library is hosting that you're getting complaints about, people are very upset about, that might be one where you want to make sure your policy is on the right side of the law and really think about strategy and PR strategy around that one with a legal mind. And then disputes over your meeting room policy, which again have been on the rise across the country, not just here in New York State. And that can look like when you open up your meeting space to be used by an outside group and they're holding a program themselves, not the library's program, but an outside organization is holding a program that has become controversial in your community. That's again where you're going to want to have the security of a legal mind helping you out there along with your public library system. And then there's going to be some key policies you need legal review of, in particular, that personnel policy, which we mentioned. And also, once you get into really big contracts that the board is signing or the director has been authorized to sign, this is going to become a very big issue if you're in a construction project. You need to have a lawyer as part of your team. But these are some of the most key and common things where we will advise a board, you're probably going to need your lawyer on this one, or we're going to help connect you with a lawyer to steer you through something like this. Certainly not a hard and fast list, and some of these have gradations in them, but this is a pretty good way to at least get a feeling for when to call the lawyer. So, Ron and Erica, I have exhausted my little prepared remarks we have here. I know we have some questions that came in, as well as some questions that are coming in from the audience already, which is probably a really good sign. So I think we're in for a fun evening here of answering questions.
Yeah, we can get right to it. That was really great, Rebecca. Appreciate it. Lots of really solid information there. If you have questions about anything that Rebecca said, or just enter any questions that you have that you're dealing with at your library, please feel free to drop them in the Q&A section. I'm going to go ahead and start us with the pre-submitted questions, but then we'll shift over in a bit. So, Rebecca, the first question that we have from our pre-submitted is, our library is an association library, not a public library. Are there laws or regulations that apply specifically to public libraries that do not apply to us? And how do we know which rules govern our situation?
Thanks, Ron, for asking that question. It's a real common one because it's a hard thing to tease out, as you know, and you might have noticed as I was going through some of the information tonight, I tried to be super clear about the ones I was highlighting and the kind of rules as they apply to publics versus association. You might have noticed I talked about the freedom of information law through that lens. The other area might be civil service law, where that applies to public libraries, but usually not association libraries. You're going to see when it comes to construction, you have to pay prevailing wage as a public library. but maybe as an association library. It's a very gray area for association libraries. So you're going to also see a significant departure in employment law between public employers, which are municipal public libraries, school district public libraries, special district public libraries, and what they call private employers, which technically are association libraries, which is sometimes a disconnect for us as we think about the fact we're publicly funded. Shouldn't we be falling under any place that says public? But the law doesn't always understand how New York State has classified our libraries. And so there is often a disconnect between what you're going to read in law and the reality of being an association library. So your system is going to be well versed in this, and they'll be the first line of defense. If you're not sure, asking at your system, they may know, they may give me a call, but they'll know like, ooh, this you might come up with a very unique situation. We're going to have to test this with a lawyer and get that answer. So I think there's some super clear areas, like I said, in employment, in FOIL, in prevailing wage, but then we've got other problems that are not so clearly defined, which is kind of the bane of the existence of both association libraries and, believe it or not, public library systems, because we were often not thought of ever in law as they wrote laws about us as well.
And that strange area is where we love to have libraries exist. That's what gives us the thrills. That's what we love.
Well, it makes life exciting, I guess, but it'd be nicer to have the answer.
It sure would. It sure would.
Ron and Eric, are there any other laws that you were thinking of? Like, there's certainly some financial issues that are different for association and public libraries. When we've talked about capital bonds and financing, there's different answers for public versus association libraries. Was there anything else that came to your minds?
I think the one that I was happy that you mentioned was prevailing wage, just because with some of the work that we've been doing with our libraries recently, the Department of Labor has been really helpful with that. And they also recognize that not everything is a black and white area and you need to have a specific ruling. And then when you get those rulings, make sure you keep it on file too. So when you go out and you ask questions and you get a response, you want to make sure that you keep those probably with that project document. And this is for anything, like when you get a lawyer's opinion, you just keep those on hand just in case it's ever challenged for whatever reason. So you have them. But yeah, and then I think how libraries handle investments for like reserve funds. You had mentioned that in your presentation, and that's one that I see come up a lot in a lot of different financial aspects of it. But I think those are the ones that usually get questions the most. And then I know freedom of information law, when you mention that one, that
Mhm.
comes up quite a bit too, that there's a bit of a difference between public versus association libraries.
And just to be clear with folks, I'm going to repeat what I said before. I think you should all have, association libraries should all have a freedom of information law policy
Absolutely.
that makes it clear the board respects the intent of that law and will follow it up to a point. Because what has happened over time, and if you came to the FOIL workshop that Kristen O'Neill did for us in this series, what you heard was the public libraries have no out when someone is abusing that law and is just there's a tsunami of FOIL requests coming in. Public libraries have to keep responding to those, where association libraries can build in recourse in that extreme situation.
Thanks, Rebecca. Our next question is about open meetings law. So open meetings law requires that board meetings be open to the public, but there are exceptions for executive session. What are legitimate reasons a library board can go into executive session, and what is the process for doing that correctly?
Ooh, big question. So, totally correct. Executive session is allowed under open meetings law. And again, that is that opportunity to have a confidential conversation not in the full view of the public, which that's what open meeting law is about, is allowing the public to come in and listen to you do the business of their library. So executive sessions, again, must be held in the context of an open meeting. So you can't say, oh, we're having an executive session tonight, no need to show up. That's not how it works. You have to announce an open meeting. And then once convened within that open meeting, someone has to make a motion to go into executive session for the purposes of. And that's where you have to be specific for the reason you're going in. Now, if you read the law, there's 8 reasons you can go into executive session. In reality, only about 4 of them apply to libraries. Some of them are tied to public safety issues for law enforcement agencies. So please read all 8. But no, it's uncommon that you would use all 8. It'd be more likely one of the other 4 when you are coming in, if you're being sued and you're discussing legal strategy, if you're buying or selling real estate and you're discussing pricing and how far you're going to go, right? You're not required to reveal your strategy for that. The most common thing is going to be related to personnel issues. And this is where boards often misstep because they'll just say, yeah, we're going into executive session to talk about personnel. Boom. You actually have to be specific. So you have to say, we'd like to go into executive session to discuss the results of the executive director's performance review. Or we're going into executive session to discuss several candidates for this position. It can also apply when you have a problem trustee. So if you need to discipline or address a major issue with a trustee, you can say that you're going into executive session to discuss an issue related to non-compliance with the library's code of ethics for trustees. So it has to be specific when you go in there. So you need a second for that motion. The board has to vote to go into executive session. Then you're allowing all trustees must stay for that. And 99% of the time, your director should stay. If the issue is your director, then you may not need them in the room for that. You can also invite your lawyer, your real estate agent, your system consultant, someone like Ron or Erica or myself can be in there with you. And then the rest of the public is dismissed from that portion of your meeting. So, blah, 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 you have your conversation, and then someone has to make a motion to come out of executive session. The time has to be marked for both going in, coming out in the minutes, and then you're coming out. And then again, just that reminder, our recommendation is that you take any votes outside of executive session as long as they don't reveal any confidential information. Because once you take a vote in executive session, you have to produce minutes within a week, which then means nothing is confidential anymore.
Well put. And also at the top, Rebecca had mentioned that Kristen O'Neill, she's done Trustee Handbook book clubs for us from the Committee on Open Government, and those are on the Mid-Hudson website. I think they're great. You should watch them. She's done stuff for us several times, and I think all the information is good. It just adds on top of one another. So that's really excellent. Thanks, Rebecca. This next one, so if the library does not have an ongoing relationship with an attorney, how should the board go about finding one? Are there low cost or statewide resources available to libraries who can't afford regular legal counsel? So what are your thoughts on looking and finding an attorney that a library can use?
I think it depends on your situation. Is it an immediate, acute issue? And oh my gosh, if we don't get legal advice now, we're going to get sued. Then you're calling your system. They're probably going to have a list of folks in the area or well known to libraries that they're going to refer you to. There's also the Ask a Library service, Ask a Lawyer service from the Empire State Library Network, but the time in which you would get a response to one of those inquiries, right, may not meet your needs for the situation that you're dealing with. So I think it probably the answer depends on the severity of the issue you're dealing with, the timeliness of the answers that you're going to need, and honestly, how much risk you're facing. So again, I think if you're starting from scratch, call your system. They're going to be your quickest avenue to getting the help that you need.
And I'm glad you mentioned risk in that one too, Rebecca. I think just about everything that we're talking about tonight, the library's trustees as well as directors have to look at like what's the risk level that we're here, and then assess that situation and move forward to see how immediate something needs to happen. So that was good.
Rebecca, how should a board respond if law enforcement arrives at the library asking for information about a patron's library use, both with and without a court order?
So this one's easy because I'm going to guess that 99% of the time trustees aren't there, right? So you're not responding. It's up to your staff and your director to manage that interaction. And that's why you need a strong policy that makes it super clear, tied to a procedure that your director is training your staff on so they know what to do. The first line of defense is going to be staff training. So they know when law enforcement officer shows up, they call the director, right? Director should be on site and the one being the point person helping that law enforcement officer. And that then becomes this delicate issue of do they have the court order or don't they? Do they have the right court order? So the director, as smart and wonderful as they may be, they might be looking at something they don't recognize, they never seen before. That's when you're calling the lawyer to help you do that. I just said the law, like yeah, you call the law. Yeah, you're calling your lawyer, you're calling your system to get you in touch with that lawyer to help you discern is this paperwork appropriate? Because in that moment, Your director is the only thing standing between that law enforcement officer and the New York State law that libraries are required to use to defend patron confidentiality. So this is where your director gets put in a tough spot because they want to be helpful to law enforcement, but they don't want to violate your patron confidentiality. So they almost can't win in this situation. They're most likely, if there's no court order, I'll just be honest, most of the law enforcement folks that we work with, they have no idea that patron confidentiality law even exists. And it's not like they're trying to get around it. They just don't even know it's there. So they're trying to do their job. They're trying to get the information they need. But the director, unfortunately, in that moment might be the first person to tell them, that law exists. I can't violate it unless you have the right court order, which can sometimes set up friction in that moment. So the more we drill on that, we train people on that, the better that tough conversation can go. But the lawyer needs to be involved to evaluate the court order to make sure it's valid for the right thing and the library doesn't release any information it's not supposed to release.
This came up recently, Rebecca, and I was working with a library on this one, and the officer had said that he's been on the force for X number of years and he's never heard of library law. And I said, "Well, there's no library law; it's civil practice law." And we had a great conversation about it, and he was really interested in finding out exactly what happened. So it can be a positive conversation, but knowing what the requirements are, what falls within a library record, and knowing how that's defined is really important for both the director as well as staff. But then getting in touch with the director and then
And
going
that's
from
a
there.
great point, Ron. That I was super impressed. One of my newer directors, she actually was introducing herself around the town, went to visit the county sheriff. And she said, "Oh, I just want to make sure you knew about this law. So in
Oh,
case
that's
anything comes
great.
up in the future, we're both on the same page about this." And again, he'd been around a long time, had no idea it was there. So maybe being proactive, that could avoid some friction when something is going down.
That's a pro tip. I bet you'd find that tip in the new director's handbook, maybe.
Maybe.
That's great. Thanks, Rebecca. All right, we have quite a few questions in the Q&A section, so I'm going to go ahead and kick those ones off. And the first one that we have is from Marty. So you stated libraries are education corporations. So when a grant program asks what type of nonprofit the library is it correct to say education corporation?
Hey, Marty, that's a super good question. Normally in grant applications, there's like a checkbox where they say, who are you? What are you? And they really just want to hear you say, I'm a 501(c)(3), which is the classification in the Internal Revenue Code that says you're a nonprofit. And then you have to explain if you have that or not. That's usually why libraries have pursued getting that as a public library. But if a public library doesn't have that, explaining that you're a government entity and therefore inherently tax exempt is something sometimes a funder is not used to hearing. So I think that you're not going to see a checkoff box for Education Corporation usually, but if you did, yeah, that'd be what you would check. That would be for public libraries.
This next question is from an anonymous attendee. Library directors are paid, so do they also get benefits like paid leave, health insurance, and time off?
So that is something to unpack because you asked several different things there. So there's many areas of leave that are mandated by law, and you'll see. So I can give you a rundown of a few of them. I bet I don't get them all, but they have leave time for there's small ones like cancer screening, bone marrow donation, voting. They have the right to leave for votes. All employees in New York State have those rights. And then you're going to start to see more complex areas of law related to sick time, paid family leave, which are not a straight answer about yes or no. It depends on public or private employer. Sometimes it's triggered by how many employees you have. Whether or not you're offering benefits like health insurance and retirement are ethical, moral questions of your board of what does an employee deserve to have a quality of life that allows them to work for your library and thrive in this world. So again, this is super complicated as you get up into those more large areas, often with larger price tags. That's where you need the HR consultant or the lawyer to guide you through those things.
Rebecca. Can the board ask our director if she's doing her continuing education?
Sure. Yeah, there should be documentation because the director has to submit that to New York State. They have to, I'm not sure if they still have to submit it, but they have to have it on file in case they're ever asked for it. But yes, I think part of if your job, your library is at a chartered service population level that requires your director to have a master's degree, or your job description for your director, regardless of your number of folks in your population, requires the degree. You can require the degree if you have a smaller population, then triggers it in the regulation. So if your job requires that certification, the director should be able to prove their compliance with that certification.
I think when I got my master's in library science, it was 2011. I think I was right on that cutoff
Wow,
point, so
good
I
point.
have to submit the 5 years continuing education. But yeah, you're right. It's just you check it off and then you have it on file in case you're ever audited. But I let my board know when I have continuing education stuff. One, because it's a requirement that I have, but I also want them to know that I'm constantly learning about these things. Most of them are just a long list of Rebecca Smith Aldrich talks that I've attended, but
You're forced
for
to
the
attend.
that I'm here chatting with you about, which is great. But they and which draws questions and they get interested in it. So it's nice to have that as part of a report out to your board too. So it's good information.
Ron, you saved the day because you brought up the fact that only folks who got certified after that date are required to comply with that those numbers of continuing education. So if you have a director like myself, I was certified before that year. I'm not required to have that number of hours every 5 years, even though I easily get that. But any strong director wants that continuing education and easily hits 60 hours every 5 years. But there's only directors after that year. I think Ron just said it was 2011 are mandated to have that. So take that in consideration if you're asking.
Our next question comes from Adrian. Our school district is merging with two others. How do taxpayers vote for funding in the future when there are three districts together and no longer one? Because there are other libraries that also receive tax money from those other school districts.
That's a tough situation. Yeah, you definitely need your system's help with that one. That's a very unique situation. So if you went from being the only library in a school district and you were voting, everyone in that school district was voting to tax themselves for your library, and now the size of that school district has tripled, and you've now got other libraries within that service area, your whole world has now changed, right? So you need to negotiate with the school district and those other libraries for how you will proceed. It will depend on what type of libraries those other libraries are. If they're similar to you, it will be easier to solve unless versus them being different types of libraries. If you've got a special district public library thrown into that mix, it's going to throw off things greatly. So that is something to immediately call your system about if you haven't already, to figure out and untangle. That's a tough one.
And that's probably a good opportunity to get legal counsel involved if you end up writing a proposition, let's say that includes all of those libraries, or if you go separate, just to make sure that the language is set in a way that is going to not come back in a negative way for any of those libraries.
Yeah, and Ron and I were talking about this before the session here tonight, that we know some of the questions you'll ask are very, very specific. So I'm sorry we won't be able to give you always definitive answers on these because there's so many little components to it. We want to make sure we steer you in the right direction.
All right, Rebecca. This next one, it's sounds like a conflict of interest. Oh, actually, they say it's a conflict of interest, so this is good. So, hi, I have a new board member who has asked twice to get his friends' children into a program when they are on the waiting list. Is that considered a conflict of interest, and is that appropriate?
I don't know if I classify it as a conflict of interest, but it's definitely inappropriate to ask for special treatment as a trustee, right? At the board table, you have collective authority with your colleagues on the board. You're making important governance decisions, but you should not expect special treatment when it comes to frontline services like checking out a book or getting into a program. You're very important patrons, but you are still a patron once you step out of that open meeting setting or a board activity. So while not a conflict of interest, I would say it would edge into an ethical issue. So you may want to check your library's code of ethics for your trustees. And if you don't have one of those, we strongly recommend it because that is someone who I think is taking advantage of their position on the board.
And that collective authority piece is such a key statement for this whole thing because when they're outside of that board table, they're just an individual person, just like anybody else. So if you're granting somebody a benefit where you wouldn't grant it to somebody else, that causes a pretty significant issue. But thanks, Rebecca.
Geraldine has a question about volunteers in the library. So how do you deal with volunteers in the library? Do you need an application, background check, things like that?
Oh, that's a broad topic. Um, So I'm going to start from the position of what type of library are you? The quick answer is yes, of course you can have volunteers. How they are managed in your library situation can be tied to whether or not you are a civil service shop, if you have a union or not. There's going to be more rules and laws and considerations for what roles volunteers take on at your library, so you have to be very careful. In general, absolutely, there should be an application. Anyone who's going to be working with children should have a background check. You should have job descriptions for volunteers, and trustees need to acknowledge that volunteers are not free. They take just as much time to supervise as a paid staff person sometimes. So please recognize your director is now responsible for managing them as well as paid staff, which requires administration, paperwork, and risk management. You guys are so serious tonight, Ron and
I
Erica.
know. I don't know. I gotta. Uh, all right, here we
There must
go.
be a lot of questions in that list.
I'm just there. We're getting through them. There's good questions that are coming in though. So if we have a single contractor who is the only response to a large bid, say around $750,000, what documents do we need to create to allow that bid to be the one to approve?
Uh, this is where I'll reiterate, we're not attorneys here. You'll definitely want to consult with your attorney on this one. I can speak from my own experience because I've had this happen at my own system. What we were advised is that you need very strong documentation of all the ways in which you advertised the opportunity to demonstrate you used very commonly used listings across the state, that you got into local newspapers, that you posted it on your own media channels. So you want to have very good documentation of how you advertise the bid opportunity. But then again, definitely check with your lawyer on that one to make sure you've got what you need to be in compliance with bidding laws.
And I mean, that's a pretty significant project to rely on one bid for too, because when you look at various bids, you kind of get a better sense of how people are going to bid it out. Like
Yeah.
if you got another one that was, 760 and one seven, like roughly you're in the same area. But if another person comes back at, $500,000, like that's a fairly sizable savings. So only having one bid, unless you're really confident that that's the price, it may be something where a rebid may be appropriate after you kind of look at what is all that, how did we get it out there? Was it appropriate enough where we were able to get enough contractors to look at it for
Yeah.
us?
In that situation I just described in Mid-Hudson, that's what we had done. We'd only gotten one bid, and we said, well, that we don't know if that price is fair market value. We need those other numbers to compare it against. So we actually went back out and had the same problem. And I think it's something that you're going to see increasingly across New York State. There's two new registration requirements for contractors to be registered with New York State, and some of them are saying no, thank you. They're stepping out of the public works area, which is putting a lot of public libraries in tough spots to find enough people to bid on jobs so they can get that fair market value and the best price for the project from a qualified bidder.
I'm concerned about that too, Rebecca. I'm hoping it'll regulate over time, but that's just my wishful thinking.
I know.
Right, we're going to talk about the census.
The
In regard,
census. Ooh,
just a little.
okay.
In regards to the number of minimum hours you are required to be open, does that change when there is a new census, or is it based on when you got your original charter?
Yeah, such a good question. The state library is very on top of this, and they issue charter population charts. So after each census, the state library will publish that chart. It will go to your system. You'll see it on the state library's website so you can check. So no, it evolves with each census what your population is. So yes, sometimes your thresholds can change for your hours and what education your director needs, which can sometimes cause some consternation. So definitely something to check in on after the next census. Good question. Gosh.
Mhm.
All right. This is a new policies question.
Mhm.
Are there examples of the new policies required?
Yeah, your system often will have examples from different types of libraries. You're welcome to come over to the Mid-Hudson Library System website. We have what we call our policy clearinghouse, where you can see examples from libraries. The key thing to keep in mind, though, when you're looking at examples from other libraries, is many of the things we just talked about. Are you looking at what area of law does that policy intersect with? Are there differences between an association library and a public library when it comes to that policy? In the employment area, is there a difference between the public and private employer issue? Is there anything being triggered by having more employees in a different library? So you can't always just copy from another library without knowing some other information about the library who you want to borrow their policy from. So your director is your first line of defense like that. They normally know, oh yeah, that library's like us. They're also an association library around the same number of employees. Other times you're not going to be so sure. Maybe you can't find exactly what you want. Your system is a good place to check in with. They might be able to help you with that. And then there's going to be certain policy areas, regardless of getting an example from someplace else, that you still want a lawyer to look it over. Particularly in the employment law area.
And we have seen policies for one library with another library's name in it. So just make sure that you read through everything and you fully understand it. You never want to adopt a policy that you don't fully understand. And for anyone who's looking at new policies and they're not sure what exactly those are, if you head over to the helpful information website, they're all listed there. There's about 6 or 7 areas that you're going to pull from. Personnel policies are on there, and that is one that Rebecca had said earlier that you're going to want to get an attorney to take a look at for you, or at least a HR specialist. But there's a handful of other ones, and you have until July 1st, 2027. That's when that goes into effect. So get those policies, approve them at your board, and you'll be good to go.
I think I said January before, Ron, so thanks for correcting that if it's July.
Oh, I'm sorry. Did I say, gosh, it's January 1st,
Oh, January 1st.
2027.
Okay, good.
Sorry. I was
Right.
probably just thinking of like what I have going on next month. But no, you're right.
It-
January 1st, 2027 is when those policies need to be done. If you
Good.
get them approved in July, good for you. But
Yeah.
January 1st.
Nice.
Thanks, Rebecca.
Yeah.
Next attendee is looking for some clarification on executive session. So if the board goes into executive session to discuss changing a director's salary, during that time, the director is asked to leave the room. They ask if it's inappropriate use, but is that appropriate use of executive session?
If you're changing if the salary discussion is tied to their performance appraisal, yes. If it's related to a normal across the board cost of living increase, no. So I think it would depend on the size of the staff, is it tied to their performance appraisal or not? The idea is that you're not revealing information that would hurt that person's reputation. Again, if I shouldn't, I guess I have to admit I've only done this for my own system. We do this little quiz with our library trustees who come to our legal workshop, where we give them little case studies and they pick the right answer of what to do. It's not just because you're talking about salary information. It's because of the reputational information about the individual that you're going into executive session. What people are paid in an organization is public information, but how you arrived at that decision for someone based on their performance appraisal is a completely appropriate use of executive session.
Thanks, Rebecca. That's helpful clarification.
This one, can a public library have 501(c)(3) status? Can you provide additional detail on that topic?
Yes, and it's not evenly applied. So I understand why I'm getting this question, and it's something I didn't understand myself when I first started working here. The first job I had in public library systems was working on a project related to fundraising in libraries, and so I was trying to discern, okay, well, who gets the tax deductible letter when you donate to them, and trying to figure out, what I was being told was that only association libraries had 501(c)(3s, but I had several public libraries in my system that also had 501(c)(3) designation. And what I learned over time is that what it seemed like is that it depended on the IRS agent who picked up the phone that day. They might have said to a public library, you don't need this. Why would I give you dual status? You already have it. You're a public entity. And others were like, okay, no harm foul, no foul. And they gave it to them. So, and you look at a list across New York State, it is unevenly been awarded to public libraries. So I've even had a library who asked twice, was told no, asked the third time, was told yes. So public libraries, I think it really depends on the day you applied for it.
Fun. Great. This question comes from David at an association library asking about school district mergers. So when school districts merge and now there are several towns within the district, does that increase in the person's district force you to be required to stay open for more hours as an association library?
So, an association library in a school district setting, you're not a school district library, you're an association library. And even though you might have traditionally had a vote along school district boundaries, it didn't change your type of library. You're still an association library. So, your service area has to be discussed now with the Division of Library Development, which your system will mediate that conversation. Because if your service area as an association library says it's the school district that no longer exists, that documentation has to change and be renegotiated with the other libraries in that region. So I don't have experience with that. I can't really speak to that. But I think your system and the Division of Library Development are going to be your best friends on figuring that out, which is a very complicated, might be a very complicated situation.
Yeah, that's a great timely question. I know there are several school districts in our area considering mergers. So
Oh, wow. Yeah, getting ahead of that. If you hear a hint of the school districts in your area merging and you have a school district vote as an association library, call your lawyer immediately.
This next one, so this may be a little specific, but we'll try to get through it. So, as I understand it, our library is a municipal library. Our school district taxes go to it's missing, but I'm assuming town, who pays our staff salaries and bills by vouchers that the library submits, according to the budget they submit to them. The village has a new mayor who's questioning why they need to provide these services. I've written to the New York State Regents in an attempt to clarify our relationship to the village, but have not heard back as of yet. Can you shed any light on how we can show the village what their responsibilities are?
Well, folks, we have just gotten one of the most complicated questions we will ever get in the history of Trustee Handbook Book Club. So thank you, whoever asked that question. So you've got a confluence of two things going on there. Now, number one is that you're a municipal public library that is not autonomous. So, under education law, if you have a vote of the people of the school district and they have voted to award you funding, the school district is tasked with collecting that tax money and turning it over to the library. That's literally what the law says. Upon request of the library's treasurer, the school district turns that money over to the library. So, in a normal association setting, that was 100% how it would work. Now, across New York State, municipal libraries have the toughest go of it because they have varying degrees of relationships with their municipality. And I encourage all municipal library trustees and directors to check out the list of opinions from the comptroller on municipal libraries and their relationship with the municipality, which I actually just put into the new handbook for library directors. Not the trustee one, but the directors one has this list of comptroller opinions, which is right on the state library's website. Your negotiated relationship with that municipality is what's going to steer how this works. So your answering of those questions is 100% going to involve your library system to help everyone understand this complex environment. And you, as the board, should understand your rights before you have that conversation, because the comptroller has consistently ruled in favor of autonomy of the library board when it comes to staffing, funding, and decisions about your budget. So this is a very complicated topic, one that we probably can't answer fully for you here tonight, but know that it's hurting your brain for a good reason because it's a hard one.
You're definitely not the only municipal library who has run into this before. And actually, there's some other resources. Earlier, Rebecca had mentioned the Western New York Library Resource Council and other councils have the Ask a Lawyer service, and there's lots of municipal conversation on those threads as well. So talk to your system and have their heads heard about this a little bit too, because it's always a fun topic.
Yeah, writing to the Board of Regents is not going to get you very far because what happens is they pass that request to the state library passes it to your system. So you might as well just call your system.
Just a lovely game of telephone.
Yeah.
So Rebecca, I am actually surprised. We hit the bottom of the Q&A ones. I have additional questions, but if anyone has other questions, put them in the queue now because we're gonna get to them. But for right now, Rebecca, I have a few other ones that have been submitted, and this one is a library director has been in their role for several years with no written employment agreement. Is that something that we should have? What should it cover, and what are the benefits to having that?
So our opinion is that yes, there should be an employment contract with your director, even if they're in a civil service environment, which is another layer of job protection and complicated understandings that you need to have about hiring people, in particular your director. But the employment contract is basically it's outlining the relationship as it needs to continue on. So it's going to clearly state the salary. It's going to clearly state the benefits. It's going to clearly state the methodology for performance evaluation. These are all things that should not be left to question by your director. It sets the tone for moving forward with them. So in this situation that was just described, this is someone you had a director for a while and there's never been an employment contract, right? It's to the director's benefit to have it. So if you're nervous about bringing it up, 9 times out of 10, that director is going to say, yeah, sounds good. I've always wanted that. But looking, and you could work with a lawyer to help craft one. Your system may have examples of ones, but it's something that should help strengthen the relationship with your director and not make them feel threatened. So think about how you approach that conversation with them, right? Make sure it's not after maybe you just had a blow up with them and now they think that you're looking to create rules that are going to help you fire them, right? That's, directors sometimes are like, where did that come from? So be very transparent about what you're trying to do, what the hope is for the future. And if you have not done a recent performance evaluation, be very careful how you proceed with that conversation because your director deserves an annual evaluation, a conversation, so they understand where they stand with the board before an action like that might be taken. So just understand there might be some unintended consequences in pursuing that, but it still is a best practice.
Absolutely. I like employment agreements, or I like when those pop up. I just see it as a professional sign of respect between the partnership that really needs to drive your library forward between the board and the library director. So it's always exciting when I see those, and I like it when libraries reach out and it's the board and the director that say, "Hey, we want to do this and let's do it the right way, and here's what we're thinking." And it's nice to see that kind of relationship even form a bit stronger through that process.
I think it also helps clarify, are you treating the director differently as an employee than you are other employees in the organization, which is rarely a good thing,
Mhm.
but sometimes necessary in very small libraries where your personnel policies might not straddle both, a full-time director and everyone else is part-time, right? So how you're writing policy in that kind of environment could also be influential in how you move forward. And again, is why you need that HR professional or legal advice.
Absolutely.
I'm going to pivot us back to the live Q&A. So Lena asks, can you say more or repeat which policies you recommend incorporate free speech principles?
Oh, what a good question. So speech principles are going to show up in your what's called either your collection management or collection development policy, which is what outlines how your director is building your library's collection. So this is what's been under fire for the past 6 years. And I just want to give a shout out to the Public Library System Directors Organization of New York State, and their investment in a lawyer here in New York, Stephanie Cole Adams, who helped write a template collection management policy and reconsideration format that any library in New York could just adopt. So that could save you some money if you don't have that one or you think yours might be out of step with current thinking. So just shout out to that resource, which you can find on the Ask a Lawyer resource that's linked in the slide we showed you earlier. Other intersections are going to be your meeting room policy. If you're lucky enough to have a meeting room that you can allow outside organizations to use, that's where you're going to see some First Amendment intersections. And believe it or not, your bulletin board and exhibit policy. So if you have a bulletin board where you allow people to put stuff up, or you have an exhibit, maybe a display case, and you invite others to exhibit items in that case, those are all areas that can intersect with the First Amendment rights. So there's there's others. There's your personnel policies actually intersect with the First Amendment and the First Amendment rights of library workers as well as the rights of employers, because that is an area that gets complicated sometimes, particularly in the era of social media. It does crop up in some interesting places, but I think it's a good thing for you to have your antenna up about because it's such a hot topic right now across the country.
Excellent.
I was going to tell my gross bulletin board story. Do we have time for that?
Yeah, do it. Gosh,
Okay,
that
it's a
sounds great.
classic. It's a
Okay.
classic. All
I
right.
don't think I know this one.
Oh, all right. I hope some people have already eaten dinner before I tell this one. I had a library. I get the call, right? How many times have I said use the call figure here? I got this phone call. Director says, she's like, all right. She's like, Rebecca, did you have breakfast this morning? I'm like, I did, but it was like several hours ago. She's like, okay, you should be all right. So she tells me she has a well-meaning patron who has been posting pictures, and listen carefully, of roadkill on the library's bulletin board. And when confronted, because the director took these down, the patron was irate, saying she was doing a public service because what if that was someone's pet and they were wondering what happened to them?
Oh my.
So trust me when I say your bulletin board policy should always have a line that says at the discretion of the director. Things can be taken down because weird stuff happens.
In a way that's so sweet, but
So,
at the same time. All right. Good. On to the next question.
please.
This one's looking for they want some library police to come in here.
Oh,
If your board has trustees who did not meet their continuing education hours, will the state take action against them?
so, super good question. So, trustee education, the mandate is in education law, right? And your duty is to follow laws and regulations that impact your library. So, my advice to you would be that you have adopted a trustee education policy that makes it clear this board complies with that law, and here are the consequences for not following this law. So, yes, to some degree, you are self-policing, but the test for removal of a trustee by the state is very, very high. So I would say that alone would not be enough for someone to come and remove you, but it could be part of a cumulative case that could be made to the state for removal of a trustee. If it was they're not complying with that law, they are violating confidentiality, it could build up to you get the attorney general involved, which we've had threats of in the past. So I think your policy is the first line of defense to make sure trustees are compliant with the law, and then following your own policy to hold people accountable and to make sure the consequences do come if someone is willfully not following that policy. Now, the board wants to have some latitude, right? You're going to have situations where, like, life intervened. Someone had a major life change or ended up in the hospital. Like, things happen, folks, right? So you want to give people a little bit of grace. But if you got someone who is flouting it in your face, yeah, I didn't do that and I'm not gonna. You guys need to toe the line and say, that's not how we do things here. You have a code of ethics. We have a trustee education policy. We follow the laws and regulations the way we're supposed to here.
And if you don't have a policy already, there on the New York State Library
Yeah.
website there is a sample one, and I'll actually, while Rebecca, while you're asking the next, answering the next question, I'll go ahead and drop it in chat so people have it. If you need a starting point for something.
Yeah, that's a very strong place to start. And what honestly most libraries around the state have adopted.
The next question is from an anonymous submitter about trustee terms. Is there a written explanation of how trustee terms work? For example, when a spot is vacant and someone joins in June, does their term begin then, or does it count as filling in for the trustee who would have occupied the vacant seat?
Good question.
This might be one of the smartest audiences we have ever had.
This is
What
this is
a
a good
good
one.
question.
Yeah.
What a good question. So the terms of your trustees are set either most likely in your bylaws, but for a special district public library, it's going to be set in your legislation. All other types of libraries, you're going to find that answer in your bylaws. It's actually not in the charter information. I think I've never seen it in the charter information. So again, special legislative district library answer is in your legislation. And then all other libraries, that rule has been set in your bylaws. So it will also depend on what likely your operational year is. Some libraries are using a calendar year, January to December. Others are using the school year, which is July through June. So that could also be a factor. Most commonly in your bylaws, you're going to see a window within which which you could appoint someone to a vacancy. So it might say, up until the third meeting of the year, in a library, it'd probably be longer. But maybe if there's a sixth or seventh month in the year, the board can appoint someone to fill a vacancy until the next election. So the other issue is, do you have a public election of trustees, or are you a self-perpetuating board, which is often the case in association libraries? So again, this is where if I had a little more information, I could give you a straighter answer, but I'm just trying to help you understand there's a couple of different intersections here, but where you're most likely going to find the answer is your bylaws. If your bylaws are silent on it, your board needs to amend your bylaws to make it clear how you handle that, because that's something you want to be really clear on. And just in honor of Laura Christie, who is not here with us tonight, you saw Kirsten is filling in for her tonight. When your director has to fill out the annual report to the state, that poor soul has to put in all of your terms one by one into that document. And boy, is it a pain. So a good tracking mechanism for when terms start, when they end, when someone didn't fill out their whole term, when someone came in and was appointed to fill that term, when people max out, if you have term limits as an association library, you should have a really good tracking system for that to make your director's life easier.
And even if you know everything about your terms right now and you feel like you're an expert on it, put it in your bylaws anyway, because a future board is going to run into this issue. Because I know we've worked with libraries before where we've gotten everything straight, and then 5 years later, it's all kind of wonky again because people have left and vacated, elected. So just put it down there and then review those bylaws if you're a new trustee, and then you'll know exactly what's going on or what's supposed to happen in the event of a vacancy or any other term questions that come up.
I have a quick clarifying question. It's ideal for terms to start and end with the fiscal year that the library is operating on. Is that right?
That's very common. Yeah. In fact, I would have said yes confidently just 2 days ago, but I'm working with a library right now where that's not the case in their bylaws. So again, go back to your bylaws. Sometimes things are not always following the same thing everyone else is doing.
Mhm.
Thank you.
Good one. Next one from Donald. Have any New York State libraries had ICE come to the door and seek to walk through the building? What should we do in this situation?
Mm. So I can't speak to that because I don't have a pulse of every single library in the state. But I will say that your library director is definitely thought this through. And if they haven't, I'd be surprised. But most systems in the state have been helping libraries consider what to do in this situation. There's been some excellent work by the American Library Association as well as the Public Library Association to share information from libraries who definitely have had this happen. But there is a very good it's like a frequently answers to frequently asked questions from the American Library Association, and I'll find it for you and put it in the follow-up email that everyone gets for things to consider and to help train your staff on so they know what to do. I know there was a heightened sense of interest in this because there was a rumor going around the governor was here in New York was going to change what's called a safe spaces rule to include libraries. But at the end of the day, when the legislative session ended this year, libraries were not added to that list of safe spaces that require a court order before immigration officers come into a space to interrogate folks. So this is a sensitive area. Your staff are very nervous about it. So if it's something that hasn't been addressed, you don't see any documentation, start chatting with your director about how you can get there because you do need to have that in place before something like that happens. So again, sorry not to have all the skinny for you on what's been happening here in New York. I can't say that it hasn't happened, but I also couldn't give you a good count of how it has happened.
Thanks, Rebecca. The next question is from Carrie. What is the correct procedure to conduct a board self-evaluation, public session or executive session?
So board self-evaluation, there's no one way to go about it. I can share with you how I do it. I bet Ron could share how his library board does it. Erica could share how her boards do it. So there's no one way to do it. Normally, there is some type of survey that each trustee fills out to share how they're feeling about how things are going or where they may need some help. Usually that's going to a committee of the board to digest and summarize into a report for the board. And normally that is something that you would talk about in an open session unless there was some information in there about an individual trustee that was maybe pulling down the experience of the whole. So I'm going to be careful here. But you could have a situation in which perhaps your board president is the problem. And in the board evaluation summary, that comes out very clearly. This is what I was referring to earlier, where we don't want to ruin someone's reputation. So then you might go into executive session to discuss the results of that evaluation. But if the evaluation are just revealing that folks wish there was an orientation to the treasurer's report, or no one knows what ALA, we don't know what that acronym is, right? Those types of things, that's fine to talk about in open session and identify a strategy for moving forward to help everyone come up in their understanding of a particular topic. I don't know. How do you guys feel about that one?
Same. I think there's a lot of different ways to do a board self-evaluation, like you said. Some libraries, like you had brought up, do a survey. I've seen some who have an outside facilitator come in and just ask really kind of strategic questions about the direction of the library, the skill sets that they have on the board, and just kind of openly talk about it and then kind of help influence other future plans that way. Some libraries will have like a full retreat where it's a day full of learning and like icebreakers and like just to get to know each other, where they're coming from, so they have a better idea of how they're working together as a unit. So there's a really large spectrum on how this can operate. And I love seeing the different unique ways that libraries come up with this, but really just kind of a basic way of doing it too is asking some questions, answering, and then talking about it. I think is completely reasonable, just so you're all on the same page with where you're going. What do you think, Erica? You got anything to add to that one?
No, I agree. And I really like the idea of doing a retreat. I think it's nice when trustees have the opportunity to get to know each other outside of the boardroom.
That's probably one of my favorite requests that I get from libraries in the system is when they're like, "Hey, Ron, we just want to do some work on the board. Would you mind?" I love being invited out to that. Like it's a
Hmm.
positive thing, and I get to experience a board that's working positively together. I think it's a lot of fun.
Yeah.
You probably get a lot of those invitations too, Rebecca, right?
I used to, yeah. But when I was a consultant, that was a big part of my work that I thoroughly enjoyed because I think it allows you as trustees to connect where your values lie. You
Mm.
get to explore more about what motivates you to be a library trustee and the things you're passionate about, but it also helps the group come together and agree on what the most important things are to work on, which then makes you just a stronger group moving forward through the rest of that year. I have a wonderful library board in my system where they do annual meeting. They call it the Blue Sky Meeting, where they get together and they talk about their hopes and aspirations for the year. And it's good to get all that out there, but also understand you have limited time and energy, right? You can't do it all in the next 12 months. So, what are the most important things to work on? So, I think that prioritization of energy also helps the rest of the year go very well for boards.
All right. When you were answering that question, Rebecca, you were talking about a possibly problematic board president, and I kept looking at this next question because it's actually the problematic secretary is what we're dealing with.
Oh.
So our secretary is routinely not getting the minutes, draft or approved, to the director in a timely way, often the day before the next month's meeting. Is that a reason to remove them?
It's a reason to have a talk with them. I would say you'd want to make sure they're aware that public officers law, the section that oversees open meetings law, is pretty darn clear. You have to have a draft posted to the library's website within 2 weeks of the meeting. That's not up for discussion. So your secretary may not know that. If they did know it and they're willfully not doing it, then I think you'd have a discussion with them about moving on or getting them some assistance, giving them that option. So I would say don't assume they know that, but also once confronted, if they're like, I just can't do that, I can't do that, then chatting about what some alternatives are. Some boards pay a staff person to come and help take the minutes to assist the secretary. Other times, the person who's in that role has to admit it's just not the right time for me to be in this role. But the board should make sure the draft is on the library's website within 2 weeks of the board meeting.
And it's an important document. So having that conversation and making sure that everybody's on the same page with it that's one of those critical conversations that you want to have because that's the record summary of all the legal actions that the board is taking every one of those motions. So it's an important thing to have up.
I always default though to thinking like no one is born being a library trustee or knowing open meetings law inside or
It's
out.
true.
So definitely give them the benefit of the doubt to start.
Except for you, Rebecca. I feel like you just knew all this stuff immediately walking
Never.
into it.
I learn something new every year. It
It's the
never
best part
ends.
of our work.
Never ends.
In follow up to that question, what happens if your library loses your secretary? They retire, no other board members volunteer to assume that role.
So my guess would be your bylaws say one of your officers is a secretary. So it's not an option to not have one. If literally no one on the board will volunteer to do it, that's when it's going to cost you some money, right? You're going to be hiring someone to take the minutes, and then someone will be more of a figurehead secretary to sign off on those minutes before they go onto the website. So I'd say one way or another, you've got to have one. So either it's going to be a volunteer or you're paying someone to help you do that.
If I can just insert one more question that I think is in this track. Speaking of minutes, how can I find out if we can use an AI transcription software for our trustee meetings?
Hmm.
So there's certainly no law prohibiting using AI transcription. You'd want to be transparent about it and just let me back up a step. You should have a policy about the use of artificial intelligence in any
Absolutely.
area of operations and governance of your library. So that's where you start. It's a policy question of whether or not that is allowed. And then part two is if you're using AI to augment a secretary's ability to take the minutes, there needs to be human intervention so that you scale back those minutes so you're not putting a 3,700 page transcription out as your minutes because the minutes should still be concise and capture the action taken at that meeting. So at the end of the day, I don't know how helpful AI is going to be for you. It'd be easier to create a worksheet that matches the agenda that makes it super easy for someone to capture who made that motion, who made the second, how did the vote go? Because that's all you really need. And right now, AI doesn't know how to do that. I'm not saying in the future AI might not, some company doesn't create some amazing AI module that does that for you, but it is not happening right now. So policy first, human intervention always.
And you need to have some of your emotions be really specific depending on what it is, especially if it's a resolution or, a critical action. And if AI summarizes that for you and misses the intent of what you're looking at, basically what Rebecca's saying, that becomes a permanent record for your library. And do you really want to rely on, possible summation of those motions to be that permanent record? So
Like,
I think it's a really good thing to think about.
I think it's more trouble than it's worth right now. And I think that you should be very careful about that public record you're creating about your meetings because it sometimes can be the center of a legal case or minimizing risk in a personnel issue. So you should not take chances with those.
And I think, Rebecca, you had mentioned the idea of like a worksheet or a spreadsheet for meeting minutes or getting those motions in there at an earlier one. And I created a spreadsheet that I like to use, and it does the same thing. I just have all my trustees in it. It's a drop down thing, so I just select them, and then it writes the motion sentence for me. It's so good, and it's just in a
Very nice.
spreadsheet. So you can make these tools that make creating these minutes just a lot easier. And then the nice thing is at the end of the day, I have my minutes, but I also have the whole year's worth of motions all in
Action.
a row. So it's pretty cool. And there's a lot of neat tools that you can use for really simple setup.
That's beautiful, Ron. Let us know how much we have to pay you to get a copy of that.
Oh man, I'll give it to you. It's all
Oh,
yours.
nice.
I'm open source. I'll send that out.
That's
Um,
fantastic.
but we are at
I,
6:30 right now.
Hey, Ron,
Rebecca,
I'm sorry to interrupt you, but right
yeah,
before we end this, I just want to say a little something about AI because it's such a big topic right now. It's
please do.
obviously a big emerging policy issue for all of the entire world. And having conversations about that, I think, is important at your board to understand the intersections with policy, and your director is probably wrestling with how this is going to impact library work. So I just really want to encourage good conversations about that and cautious applications of it. Not only for the environmental impact, we shouldn't be using it without thought, but also because of some of the other implications that could really compromise your duty of care and loyalty to the organization.
I don't know if we could do a whole trustee handbook book club on AI. We'd have to get some expert to come in and do that, but it's definitely a huge topic for
I think we
sure.
could. Yeah.
Yeah. Yeah, so thank you, Rebecca, so much for such thorough and grounded work and a walk through all this material. To Erica for co-moderating, for Kirsten for being able to handle all the technical issues, and thank you to everyone who joined tonight and brought such good questions to the conversation. This session does qualify for trustee education, so I'm glad that you were able to hang out with us for an hour and a half as we talked through everything. And before we close, I just want to mention a few of the upcoming sessions for the Trustee Handbook Book Club and the Director Handbook Book Club. So in October, Rebecca's going to be moderating a panel discussion on the duties and responsibilities of key officers. officers. The Director Handbook Book Club, all sessions are during the day for your directors. We'd love to see your directors there. And the next one's on September 25th, where I'll be presenting on the director and board relationship. So I'm really excited about that one. On December 9th, Rebecca will be moderating an interview with Lauren Moore, Assistant Commissioner of Libraries and the New York State Librarian, and Annalee Dragon, Executive Director of the New York Library Association. On the library network in New York State, we encourage directors, trustees, everyone to come and listen to those conversations. Registration links, you can find those at midhudson.org/trustee book club. And all the sessions will be recorded and count towards your 2 hours of required education through 260D. And again, thank you so much for being here tonight. We really appreciate it. We look forward to seeing you at the next one. And thanks for all the incredible work you do. Erica, Rebecca, again, thank you so much.
Thank you. Nice to
We'll
see
talk to
everyone.
everybody later.